Good afternoon and welcome to the Environmental Law Institute. You've joined us for Basics of Clean Air Act. My name is Hannah Keating and I'm the Manager of Education Programs here at ELI. We're delighted to welcome everyone to this 5th seminar of ELI's annual Summer School series, and I encourage you to join us here at ELI every Tuesday for Summer School. For more information, please see the events page on our website, eli.org, and thank you all for joining us. At the end of today's panel, we will have time for a question and answer session, and we encourage you to ask your questions at that time. If you're joining us in the room, we have a microphone to bring around at that time, and if you're joining us through GoToWebinar, please submit your questions through GoToWebinar's question box, and please do not wait until the end. Ask your questions as soon as you think of them. I would like to also thank our outstanding panelists for joining us today to lend their expertise to the summer school session. While I introduce them briefly in a moment, their full speaker bios are posted on our website, www.eli.org, and I would encourage you to check out their expertise and experience in more detail there. As we begin, I would like to briefly introduce our panelists. Sarah Colangelo is the Director of the Environmental Law and Policy Program and an Adjunct Professor of Law at Georgetown. Prior to her time at Georgetown, Sarah served as a trial attorney for the Environmental Enforcement Section of the Environment and Natural Resource Division at the Department of Justice, my apologies. Sarah, we're delighted to have you here today. We also have Martha Roberts. Martha is a senior attorney and part of the U.S. Climate and Legal Regulatory Program at the Environmental Defense Fund, where she works to support climate change mitigation and secure clean air through policy initiatives and strategic litigation. Her areas of expertise include federal environmental and energy regulation, the Clean Air Act, greenhouse gas emissions from the power sector, and more. Thank you so much, Martha, for lending your expertise to us today. And last but not least, we have Don Elliott. Don is a senior of counsel and co-chair of the Covington and Burling's environmental practice. He has extensive regulatory experience in the clean air regulation, and during his tenure at the EPA, Don played a crucial role in drafting and implementing the 1990 amendments to the Clean Air Act, including helping to draft the acid rain permit trading statute and regulations. Don, we are delighted to have you here today. And with that, I'll turn things over to you. Thank you.
Good. Thank you very much. Well, it's a great pleasure to be here and to talk about one of my favorite topics, the Clean Air Act, which is about to celebrate its 50th anniversary. I've been writing a biography of the Clean Air Act for the last few months, and I called the talk today a critical history of the Clean Air Act. So the critical history will come in just a couple of remarks at the beginning. The Clean Air Act is really an extraordinary piece of legislation. It would be hard for anyone who didn't really live through that period, and I'm probably the only one in the room who can claim that he did, to appreciate what a difference it's made. When I first spent a summer in Washington in the middle 60s, I was living on Connecticut Avenue, and I remember days when you literally could not see across the street because there was so much air pollution that burned your lungs and was acrid. Of course, that is something that really never happens in Washington and rarely happens anywhere in the United States. So it's an example of successful social change through law, which is something that I think we're all quite interested in. Now, it's hard to think of any legal initiative. You can think of one or two, but there aren't very many legal initiatives in the 20th century, and I realize we're in the 21st century, but this took place mostly in the 20th century, that have been really successful in changing the world. So it's interesting, not only in and of itself, but also as a model of successful social change. It uses a technique which is typically called legalistic bureaucracy, which is a variation of an ideal type by Max Weber. And basically what it means is that rather than taxing pollution or going out and cleaning up pollution or generating electricity with low emitting sources, the basic technique is to write rules. So the mainstay of our approach to the Clean Air Act is to create an agency that writes a lot of legal rules. That's not inevitable. You can imagine that things could have gone in a different way. In fact, the Nixon administration, before creating EPA, actually proposed a sulfur oxides tax. So, you know, one of the ways to deal with pollution, as we talk about carbon taxes with Martha and others, is to tax it. And we did explore that approach. It's largely the road not taken. Most of the critics of the Clean Air Act are what I call friendly critics. There are people who recognize what a great accomplishment it was, but argue that in one way or another we could have done better and we could have learned lessons. And one of the things that struck me as I studied it is how long and slow some of these things are. One of the very first cases that I worked on as a law clerk right out of law school was I was clerking on the DC Circuit, and we had the case that involved an EPA rule to take the lead out of gasoline, which was at that point. Well, EPA has been very successful in getting lead out of gasoline. The lead is one of probably the most successful reduction of air pollution. But between 1970 and 2005, the emissions of lead to the air have been reduced by 96%. So that's a pretty extraordinary record. Other pollutants have been reduced less. Ozone is down by about 20%. Most of the combustion products, the NOxes and sulfur oxides are down between 1/3 and 2/3. But this is at a time when our economic growth has basically doubled. So we have a very impressive record of cutting down on air pollution. The critics, though, argue that it was slower and more expensive than it really needed to be. And one of the things that struck me was it took EPA 25 years to complete banning lead in gasoline. And so a lot of these techniques are effective, but they can be slow. Okay, so the Clean Air Act consists of really three major amendments. There actually are various Clean Air Acts going back to 1955, but these are the big ones. And what we call the Clean Air Act today are really the Clean Air Act amendments of 1970. And the major thing that the Clean Air Act amendments of 1970 did was take the regulation of air pollution, which for about 100 years had been run by states and localities, and create a significant federal role for regulation of air pollutants. They did that through a technique called cooperative federalism. I actually noticed ELI has a book out there about new versions of cooperative federalism. So, but the idea behind cooperative federalism was a great term. The idea was that the federal government would basically define the goals, but it would leave the dirty and unpleasant work of implementing it to the states. What a great position to be in. You know, you get to announce the goals, and then you get to denounce the people who have it. But anyway, it came after 20 years. Cooperative federalism was originally a Republican term. It came after 20 or 30 years to be referred to pejoratively as unfunded mandates. So unfunded mandates and cooperative federalism are two sides of the same coin, and that was the mainstay of a lot of the initial round of regulation through state implementation plans and the National Ambient Air Quality Standards, which both Sarah and I will talk about a little bit. Another major accomplishment of the 1970 Clean Air Act was the concept of technology forcing. Basic idea behind technology forcing is if you pass a law saying eliminate air pollution, they will come. People will find a way to do it. Turns out that works sometimes and doesn't work other times, and we don't fully understand why it works sometimes and not other times. I could give you examples, but I won't. The other thing that was notable about the 1970 amendments is they were very aspirational, and they really invented the idea of deadlines in a statute for administrative agencies. So the original Clean Air Act declared that we were going to eliminate air pollution, at least hazardous air pollution in the United States within 5 years. We didn't make that, in case you didn't notice. About 20% of the country still lives in areas where the air violates the EPA standards. But at least we had the goal. Originally, Nixon proposed to eliminate air pollution in 10 years. That was largely because he was imitating Kennedy's proposal to go to the moon in 10 years. He asked his staff, what could I do in 10 years? And they said, eliminate pollution. So they proposed to do that. And then Muskie, who was running against him for president, cut it back from 10 to 5 years. But then, of course, one of the problems with that is the 5 years came and went. And we hadn't eliminated air pollution, so we had to have a second set of amendments. And those are the 1977 amendments, which again, we'll talk a little bit more about. They're kind of a mid-course correction. There were some things that when we passed the original 1970 law, we didn't anticipate that sort of showed up. Probably the clearest one is the National Ambient Air Quality Standards were set on a uniform basis. So what happens if you have uniform standards? And those of you who have had some exposure to the concept of incentives in law school or whatever, what happens? You can build a plant without controls as long as you build it in a clean area. So as a result of the uniform national standards in about 1975, you could go out and build a steel plant next to the Grand Canyon, but you couldn't build it in Pittsburgh because there were already a bunch of other plants in Pittsburgh. So the Congress said, oops, that's not exactly what we intended. And in fact, in a pattern that we'll see repeated over and over again, it was really the courts and the agency that ran into this problem first, figured out an approach for how to deal with it. And then Congress came along and said, oh yeah, that makes sense, and usually makes it a little bit stronger. So that was the development of the Prevention of Significant Deterioration program. And also the other side is, what are you going to do in those areas that aren't meeting the national standards? So those are the two, the 1970 and 1977. 1990, which was the rewrite of the Clean Air Act that I was involved in as general counsel of EPA, was only a partial rewrite of the statute. But nonetheless, we basically shut down Congress for a year. There was a whole year where they didn't do much of anything other than focus on the Clean Air Act. So that will give you some idea of how difficult and expensive it is to really innovate through legislation. But we added the acid rain trading program, Title IV, which is the first major use of tradable permits or tradable rights really anywhere in the world. We toughened the air toxics provisions of the Act. And one of the things that we did on the air toxics provision that was good, and we don't always do, is we actually looked at what portions of the statute were working best, and we modeled the portions of the statute that didn't work very well on the ones that did work. Duh. But people don't always do that in law. And the other thing that began to emerge in the 1990 amendments is that many of the air pollution problems in the United States do not respect state lines. They're regional. My home state of Connecticut, the air that came in from the west already violated the National Ambient Air Quality Standards. So if Connecticut shut down everything, they'd still be in violation, right? So we hadn't really anticipated that in the original statute. In 1990, we did build into the statute something called the ozone transport region, which was a recognition that ozone problems on the East Coast were really a regional problem, not a state problem. And we had some provisions providing for other regional approaches. One, which isn't part of the statute, but is an illustration, is the RGGI program, the Regional Greenhouse Gas Initiative in the Northeast. So it's a regional trading system for greenhouse gases. And I used to think that we were going to get legislation in 2003 or 2004 that would deal with trading system for other pollutants and deal with CO2 and carbon. I now have taken to putting 2 question marks there. It's not even clear to me what decade. But just to show you, a few years ago, I participated in a program that ELI had sponsored about lessons from implementing the 1990 amendments that we could use in implementing the legislation that we're going to pass any day now to deal with climate change. So, as Martha will talk about, one of the great failures of the Clean Air Act is the inability so far to come up with a really good sustainable approach for dealing with climate change issues. And we tried to do something, but to the extent that we are going to eventually deal with climate change, many people think the acid rain trading program provides the model. That was the model for the Waxman-Markey bill that passed the House. Some of us have come around to the view that, well, we take a tradable rights permit program in a minute, but there are some advantages possibly to an emissions fee. So that is a sort of internecine battle. But right now we really don't have either. One of the reasons, I mean, it didn't occur to us in 1990. Actually, the acid rain program only ran for 20 years because it was inconceivable to us in 1990 that we would go 10, 20 years without re-amending the Clean Air Act. So again, wrong again. But one of the reasons that we haven't had more statutory amendments is the so-called Chevron doctrine. How many of you in the room are familiar with the Chevron doctrine? Okay, so about a third. So I will explain it a little bit more later. But basically what the Chevron doctrine does is it gives agencies much greater authority than in the past to interpret legislation, to essentially fill in the holes in legislation. It's not just ambiguities. Ambiguities are one thing, but also there are lots and lots of problems that come up that Congress never thought about. And in the Chevron doctrine, the courts basically say, well, if the statute doesn't specifically address this issue one way or the other, then that should be presumed to be an implied delegation of authority to the agency. And we'll talk about that a little bit more. But because of that, many of the problems, including the regional problems, have in fact been dealt with through interpretations, right? Through interpretations. It never occurred to us in 1990 that we could do a trading program without the benefit of specific authorization from Congress, although I did write a legal opinion after Chevron saying that we could. But that's really become the mainstay. Rather than amending the statute, the agency has, I think, very creatively interpreted its statute to give it the authority to implement trading systems for pollutants other than the sulfur oxides that were specifically part of the acid rain trading program. So we have multiple trading programs now, particularly for other pollutants. Again, though, it took 25 years. There was actually a provision in the House legislation that would have given EPA standby authority to create trading systems for other pollutants. Well, we would have saved 25 years if that had passed, as opposed to having to do it by interpretation and litigation. Okay. Another main feature of the Clean Air Act is that it really is a toolbox, and that's one of its brilliant aspects. It also, over time, creates a problem. What I mean by a toolbox is people who wrote the Clean Air Act knew that they didn't, and I actually, before they died, had an opportunity to interview some of them, including Leon Billings, who was the primary aide to Senator Muskie and was really the main author of both the Clean Air Act and the Clean Water Act. They knew they didn't know how to solve this problem. So they threw at it authority for EPA to do a whole bunch of different things and have a lot of different approaches. And they decided then that they would allow the agency to try to figure out what the best way to address this problem or that problem was. So a lot of different authorities, some of which have almost never been used, some of which have become more predominant over time. But there are two main systems. The first system consists of is cooperative federalism. It consists of the National Ambient Air Quality Standards promulgated by EPA, and then state implementation plans, which are promulgated by the various states and then approved by EPA. Or if the state doesn't get its act together or doesn't come up with an approvable plan, EPA can come up with its own, which is called a FIP, a Federal Implementation Plan. It's also a transitive verb, which gives great testimony to the flexibility of the English language, as in FIPM, so substitute a FIP for a state implementation plan. And then in the 1990 amendments, again, adopting a technique that had worked well under the Clean Water Act, we came out with individual facility permits. So again, same pattern of seeing something that works in another statute and incorporating it. But there's also a second system, which I call direct federal regulation. Some of that has to do with automobiles, which have always been regulated directly by the feds. But also there are systems for new source performance standards and for air toxic standards, which are called NESHAPs, National Emission Standards for Hazardous Air Pollutants, or sometimes called MAC standards, Maximum Achievable Control Technology Standards. And those are rules that apply directly to emitting facilities, which, by the way, are called sources under the Clean Air Act. I don't think I'll live long enough to do it, so I'll pass this on to one of these days. I'm going to write a book about, or write an article at least, about the euphemisms under the Clean Air Act. You know, we don't have a pollution, we have emissions. We don't have polluters, we have sources. But in any event, those direct federal actions apply directly to the sources of air pollution. And I think that Sarah is going to talk about both of them in some detail, so I'm not going to spend too much time on them, other than to identify them. And to say that it was very interesting that initially, to get out early, you know, they used this cooperative federalism plan of state implementation plans and federal standards. And that got into play pretty quickly. Over time, the EPA has just continued to issue one after another of these direct federal regulations. So, you know, every glass plant in the United States, at least new or modified sources, have to apply best available control technology to control pollution. So two different approaches. Over time, the direct federal regulation takes on a greater role, and there are like 148 different types of industrial facilities that are subject to some sort of EPA regulation. Two consequences of the toolbox philosophy. Number one, the system gets really complicated over time, because an individual source of pollution has to comply with, you know, 5, 6, 7 different regulatory systems. And that also leads to the complaint about too much regulation, too much red tape, because over time you just get more and more complexity building up. Okay, I'm not saying much about Title II mobile sources. It's a very important part of the system. It's probably the area where there's the clearest case for the need for federal regulation. It's a very interesting system in which California is given a special role and ability to regulate more stringently, in part because they were all regulating when the feds got into the business. A car today emits about 90% less pollution out of the tailpipe. Some say 95, 98% of what one did in 1970. But about half of the pollution benefits have been eaten up by an increase in vehicle miles traveled. So, you know, we use cars more and we travel more. We get the benefit of that, but not 100% of the reductions that come about technologically are benefit the environment. Some of them go into increased consumption. And one of the things that we did in 1990 is start regulating the fuels, not just the vehicles. We discovered in 1990 that the majority of air pollution from a car was actually coming from emissions from the gas tank rather than from the tailpipe. So we'd already squeezed most of it out of the tailpipe. So we've moved on to regulating fuels as well. The world of the Clean Air Act is divided into several titles. Title I, which is a good title, is one that I'm interested in, is about stationary sources. And that has multiple programs, which we've mentioned briefly: the National Ambient Air Quality Standards, state implementation plans, the Prevention of Significant Deterioration program, and the Nonattainment program, which together are sometimes referred to as New Source Review, and the national NSPS stands for what? New Source Performance Standards. And NESHAPs are National Emission Standards for Hazardous Air Pollutants. Basically, the idea is that the National Ambient Air Quality Standards are going to regulate what are called ubiquitous pollutants. or sometimes criteria pollutants. Those are the pollutants that are more or less found everywhere, not literally found everywhere, but most of them come from burning fossil fuels. So those are national standards that apply all throughout the entire United States. Whereas niche apps are more focused on local sources of air pollution, so a chemical plant that's releasing carcinogens into the local environment will be regulated separately. And again, Sarah, I think, is going to talk more about those things. The state implementation system consists first of developing essentially a literature review, which is called a criteria document. And then EPA goes through notice and comment rulemaking to develop under Section 109 national ambient air quality standards. And then that triggers consideration by the states of developing state implementation plans, which are really simply collection of emission limitations. One of my most embarrassing moments is when I was a junior associate and I marched into Region 7 in Kansas City and announced that I wanted to see the Missouri State Implementation Plan. The guy looked at me like I had two heads and pointed me to this big file cabinet and says, "It's over there in the corner." So, you know, you think of it as a plan. It really is just a collection of all the legally enforceable state regulations, which together are supposed to add up to compliance with the National Ambient Air Quality Standards. So there will be a bunch of laws or administrative regulations in Indiana, and those will be bundled together and submitted to EPA for approval, saying, here's our state implementation plan. So plan is a little bit of a misnomer. And I'll leave to Sarah the SIP calls and FIPS and all of that. One of the things that developed in 1977 and subsequently is the development of the New Source Review Program, which basically was based on the idea that new sources would be regulated more stringently than existing sources. And in a tribute to the legal mind, the word new does not necessarily mean new. It also means if you change your facility, if you make physical or operational changes in the facility, then that can cause it to be considered a new facility. Or if you modify it, modification is something that increases the emissions. Both of those things will trigger a third system of regulation, which is called the Prevention of Significant Deterioration Program, or PSD. So basically, the National Ambient Air Quality Standards are health-based, which are called primary standards, or secondary standards, which are based on welfare, like preserving visibility, eliminating acid rain. And then the third level are prevention of significant deterioration increments. And basically, those are roughly 10% of the National Ambient Air Quality Standards. And basically what they say is, if you have a clean area that's already meeting the National Ambient Air Quality Standards, you can make the air a little bit worse, but not too much worse, right? So you can make it a little bit worse by building a new factory, but there are a number of requirements, including that if you're going to build a new factory, it has to have best available control technology. So again, a lot of this is really very precautionary regulation. You don't have to prove that there's a problem with the new factory. It's just a basic notion is if it's going to be a new factory, it ought to have pollution controls built into it that are, you know, the best that are reasonable under the circumstances. Okay, new source performance standards are probably one of the most successful portions of the Clean Air Act. We at least thought they were in 1990 when we adopted the basic approach of new source performance standards for air toxics issues. It's basically an engineering program, and it requires EPA to study categories of sources, look at the best performing sources, and essentially make everybody come up to essentially the level that the best controlled sources are already doing. What is interesting about the program, and I think has accounted for it being not so controversial, is if you go back to the National Ambient Air Quality Standards, there's a famous case, the ATA case, that basically holds that you can't consider costs in setting the health-based standards, okay? So that's the American Trucking versus Whitman case. So costs are not considered in setting the National Ambient Air Quality Standards, they are considered in setting new source performance standards. Okay, so it's not a health-based standard, it's just the principle if you're building a new plant. So it's a little bit more leeway to consider economics there, and that's made it, I think, somewhat less controversial than some of the others. The air toxics provisions were not working in 1990. We spent 20 years and we had only regulated 7 substances. And so we kind of completely retooled that system. When I say we, it wasn't so much the first Bush administration as it was the National Resources Defense Council. You know, we wrote Title IV, the acid rain trading program. They wrote the Section 112 relating to new source national emission standards or NAC standards. And it's a very interesting approach. Rather than going through and having a record on the science, the statute just lists 189 substances by name. Okay, so now here's a test. Where did Congress get the list of 189 substances? Anybody? EPA gave it to them, right? So they said, what do you want to regulate? Give them a list of 189 substances. Okay, we'll put them right in the statute, right? But what it does is it basically reverses the burden of proof and says that EPA would have to make a scientific case that something can be safely delisted rather than build a case that it should be regulated. I'll go real quick from now. I won't spend much time on bubbles. That's a program that was implemented by the Doug Costel and the Carter administration. And the idea was that rather than regulating each particular emission point or leak in a factory, you could just imagine it covered by a single bell jar or bubble. And so you could regulate it on an aggregate basis. And whether that was legal or not was the issue in the Chevron versus NRDC case. The bubble policy was challenged by the Natural Resources Defense Council. And in this famous opinion, in Chevron, basically the court said there are 2 issues. First of all, did Congress decide this particular issue? And if not, it's an implied delegation to the agency to defer to any agency construction if it's reasonable. So that's been a very important principle of administrative law, not just under the Clean Air Act, but in administrative law generally. And it's generally viewed as having moved a lot of power and authority from the Congress and from the lower courts to administrative agencies, to giving them a lot more authority than they had previously. Okay, acid rain trading program, basically the application of a bubble policy to the country, to the entire electric utility industry, at least in the eastern half of the country. And it achieved extraordinary success at relatively low cost. At one point, 50 people in the acid rain trading office at EPA had gotten half of the pollution reductions, and the other 17,950 people had gotten the other half. So, you know, it was a very successful program in terms of achieving its goals. And it did it at really less than half the cost of traditional methods. So that's why it's been on a pretty much a bipartisan basis, the model for potential multi-pollutant legislation and climate legislation. I talked a little bit about regional issues. There were a couple of provisions in the Clean Air Act in Section 126 and Section 110 to try to deal with pollution that started in one part of the country and then went to another part of the country. It didn't really work very well. And one of the big problems is we had great difficulty getting pollution and regulating where the pollution starts in one state or starts in multiple states and then comes down someplace else. So using its power under Chevron, several successive administrations on a bipartisan basis came out with several different rules that eventually were eventually upheld by the Supreme Court, that by interpretation essentially allowed a trading system across states for other pollutants. So it's quite interesting that they developed something by interpretation that prior to 1990, we had always assumed would require legislation. Last thing I want to talk about today is a little bit of enforcement. I have a little article called The 5 Best Things and the 5 Worst Things About U.S. Environmental Law that I did in did a lecture in 2010 in Taiwan. Enforcement, really one of the best things. I think one of the things that differentiates the United States from most other countries around the world and the international realm is the ability to enforce laws. When we were modifying the enforcement provisions of the Clean Air Act in 1990, we observed, I observed actually, that 80% of the successful enforcement cases that had been brought under the Clean Water Act. So we said, oh, well, let's, this is basic Deming, if you've ever heard of Deming. Look at what works and try to duplicate it, right? So if we're bringing so many more enforcement cases under the Clean Water Act than under the Clean Air Act, and this is back in the Carter administration. There was a study by GAO that said, well, we got all these beautiful regulations. 90% of our sources are not in compliance with them. So the changes that were brought about in 1990 have been really crucial. And one of the main ones is to require self-monitoring and reporting. So we required all of the sources that were covered by the acid rain trading program to have continuous emission monitors, which are basically little computers that constantly read the amount of pollution. So once you can meter the pollution, it makes it much easier to enforce. When I first got into this area, the state had to give you 60 days notice that they were going to come and do an inspection of your facility, do a stack test. So these utilities, they would have a pile of coal that was clean coal. They call that compliance coal. And so when the regulators are coming, hey, Joe, start using the clean coal. Well, the continuous emission monitors and and then I think another feature is the redundancy. And this is a big problem in most other countries, that the government really can't enforce the law very well, particularly against powerful interests, including the government itself. And so our laws in the Clean Air Act, but under most environmental statutes, allow requirements to be enforced in court by the federal government, by the state government, right? And then here's the really unique part. Citizens, affected citizens, for which you can really read environmental groups like the Environmental Defense Fund or NRDC. That's what's really unique about the U.S. system, and it's really one of the key things that that makes it work. So the multiplicity of different ways to enforce, and the provisions of criminal penalties. But there are countries in the world, like in the European Union, that use a lot of criminal penalties, but they're not nearly as effective as we are in actually enforcing their laws. They just put a few, factory managers in jail, which the factory managers find unpleasant, but it doesn't really change things. Here, I negotiated a consent decree a few years ago in a case brought by Peter Lehner, who at that point was at the New York Attorney General's office, subsequently was the executive director of NRDC. And the consent decree provided for $1.1 billion in pollution control equipment as a way of settling this case that had been brought by EPA, but it was also brought by four of the northeastern states, and they were really driving it. EPA was also a plaintiff and did a good job, but it was really the states and the ability of states and environmental groups to really drive things, and that's what's different about the U.S. system. That's the main thing that's different about the U.S. system. So one of my 5 best things about U.S. environmental law is the potential for citizen suits to actually enforce the law. And we have a second kind of citizen suits, and I'll mention that, and then I'll be done. And that is another unique feature of U.S. law is groups of affected parties can not only bring suits in court to require the government to enforce the law, they can bring suits in court to force the agency to take action and to regulate. Those are sometimes called statutory mandamus suits. So it's a different version of a citizen suit. But if Congress says, as they did in 1990, regulate 1/4 of the 189 sources of air toxics in the country in 5 years, if the agency doesn't do it, and a citizens group can go to court and get a court order that will require the agency to do it. A study, just to give you an idea of how important this is, a study by the Environmental Law Institute a number of years ago in the 80s suggested that 88% of the regulations that EPA did, it did when it was under court order to essentially live up to the requirements of the law. So very interesting system. I think it's got some very good principles in it that can be adapted and used in other areas. And with that, I will cede the last 2 minutes of my time to my colleagues. Sarah, you want to go next?
Sure thing. Thank you so much, and welcome everyone. It's a pleasure to speak with you. It's great. I have some familiar faces. Some of my students are in the audience, and that's fantastic. So as the folks from ELI mentioned, my name is Sarah Colangelo. I am the director of the Environmental Law and Policy Program at Georgetown Law. And in that capacity, I wear a whole heck of a lot of hats. I'm happy to talk with anyone afterwards about some of the administrative parts of my job, which involve actually sometimes putting together events like this one. Or if there's a very interesting Supreme Court case on an environmental issue, sometimes we'll have the panelists come right back, or the advocates come right back and speak at Georgetown, which is fun. But some of my job involves what you might guess, which is teaching. So I teach environmental law. I teach multiple advanced environmental law seminars, which are more targeted at practice-based issues like strategic thinking and planning a case. And my own background is in environmental enforcement, and I want to echo the things that Don just mentioned. I completely agree. It is a very unique and a very powerful attribute of our federal environmental law system, or I should say our national environmental law system, because of that redundancy. I have the honor to meet with a delegation of French ministers this week, actually, to speak about environmental enforcement best practices. And these happen to be some of the things that I'm going to bring up there. But today we're focused on the Clean Air Act. And I think they probably gave the academic on the panel the boring stuff. So you got to hear this tremendous historical
one of the
back.
Two academics on
yes,
the panel.
One of the two. So, and I don't even know if you mentioned this, but Don is an adjunct professor at Yale Law School, and taught me administrative law. So when he was at Georgetown. So yeah. So you have this tremendous historical look from someone who lived and breathed it, and then you're going to hear about hot topics in the Clean Air Act, and I get to tell you about the nuts and bolts of the Clean Air Act. Okay, so but as you've gleaned from this presentation or some of your own experience, the Clean Air Act is probably one of our most, if not the most complex regulatory scheme that we have in terms of federal environmental laws. And when I approach this topic with students or newer practitioners, what I try to do, hopefully somewhat successfully, is to break it down and start with some of the themes that we see echoed throughout our federal environmental law system. This helps give us a foundation for why we need this regulation and why it looks like it does today, which you heard echoed a little bit in Don's presentation. So with that, let's see if this will go through this a little bit. Okay. So the first thing I want to throw out there are some themes that we see in federal environmental law. And the reason I do this is, again, the Clean Air Act really typifies the complexities and the challenges that we see in this system. It's all in there for the Clean Air Act. The myriad of regulatory design choices we face when trying to solve issues of human health and environmental harms, technology-based and technology forcing regulations. We've got issues of federalism. We have regional issues. We've got, you see all sorts of issues surrounding economics, politics, what's called command and control regulation versus innovative or more incentive-based approaches. You heard Don mention things like bubbles and offsets and emission trading programs. These are all complexities and nuances that we find within the Act. And then, of course, we see hot topics, political questions, transboundary questions, and tremendous questions regarding current events and current issues like climate change, and Martha's going to speak about that. So let's talk about why we need regulation in this area. And some of this was hinted at what in Don's presentation, but I think it's worth talking about, because as he said, we could have taken different approaches, right? We could have done something that looked more like a tax or an incentive-based approach or a universal trading-based approach. So why did we end up with a system that we have today? If we think about that and we approach trying to put together all of this acronym soup for these different programs, I think it's going to help us understand that a little bit more. So we can ask ourselves, why do we need air pollution regulation? And the first thing to ask is, well, why does this pollution occur? It occurs for a couple of different reasons, and most of the rationales actually for environmental regulation of this type come from economic concepts, okay? So concepts like externalities, that is a side effect or consequence of an industrial or commercial activity that affects other parties without being reflected in the costs of the good or service. So a common example of something positive might be if you're a farmer and you have some bees that you're keeping on your site. Well, there's no cost to this, but your bees are also pollinating your crops. That's a positive externality. Pollution from an industry, or a source, if we're going to use a euphemism, that's a negative externality, okay? And then we have concepts, and you all probably are already familiar with this, like tragedy of the commons. Here, putting something like pollution into a common media, and the rational actor finds that the cost of disposing of their share of the waste is less than the cost of purifying it before it goes into the common media. So then we have to ask ourselves, well, why can't market forces alone solve this problem? Why do we end up with this complex system of regulations that we just heard about, okay? And it happens for a couple of reasons. So in order for a market-based system alone to solve this, it would require stuff that just doesn't exist when we talk about our current system. So number one, as I mentioned, pollution externalities, they cross borders, they're mobile. Air, water, they're going to move around. So states don't have much incentive to abate their own interstate pollution. And here again, we're particularly talking about air. The water, of course, moves as well. So that's going to require some type of higher authority to regulate that type of pollution. Also, common media like air can't be privatized. So we can't solve this just through privatization. Other issues that I just put on the slide there, free rider problem that we would have. Oh, this state over here might do something about it, so why should I bother to clean up my own pollution? And again, market-based approaches and rational actors require things like perfect information. Again, that doesn't happen here. Often polluters or sources They don't know the exact extent of their polluting activities, where the emissions might go. That's actually a very, very complicated situation that would require high-level modeling. And the victims of pollution often don't know that they've been exposed either. So there's a lot of issues there that we can see. Regulation and setting standards is probably going to happen when we talk about air pollution. All right, and we have other things. You've probably heard some of this before, so I don't want to repeat if you've heard it in law school already, but issues which is commonly called something like a race to the bottom, where you have states deregulating in order to draw business to them. So these are all reasons why we end up with the regulatory structure that we have under the Clean Air Act. All right, so, and again, I'm just skimming here. I think some of this has already been talked about in terms of the structure and the concepts like federalism that we're going to touch upon in a little bit. But again, these are all the regulatory design choices that we see in the Clean Air Act. And by that, I mean, what is the regulatory strategy or the tact that a specific program takes vis-a-vis a source or a type or a particular type of pollution. And we're going to talk about that. We're going to drill down a little bit deeper into that throughout this presentation. But again, we see some really interesting issues come to the fore here. And I know Martha is going to touch on some of them, but just to take one example that was hinted at in the earlier presentation, for example, mobile versus stationary sources. So, you know, at some point, we say, well, which type of pollution, which source, or which category of sources should we focus our efforts on? And one thing that's really happened is that stationary sources have really been regulated to the hilt in some sense. Mobile sources, though, yes, they've been regulated. Yes, there's been great progress. But mobile source regulation tends to touch everyday regular Americans. And there's consequences to that. People want to drive their cars the way they want to drive their cars. They want big trunk space. They want the ability to drive far and fast and have certain features of that mobility. So once you get into that, you have sometimes public outcry for certain reasons over mobile source regulation, and then that can translate into political intransigence to regulate those types of sources. So all of these regulatory design issues we see crop up when we talk about the Act. Okay, so in terms of our structure here, Don talked a little bit about this, so I won't belabor this, but we're going to focus on Title I and Title II in my part of the presentation, and a little bit of Title V for our operating permits. Okay, so the first thing we're going to talk about in a little bit more detail are the NAAQS. And so you just heard that through that exercise of determining what is the right regulatory strategy or set of strategies to deal with this. I'm sorry, everybody, I'm off my notes here. With this particular problem, we know that EPA is charged with listing criteria pollutants, and these are widespread air pollutants that reasonably may be expected to endanger public health or welfare. The presence of these pollutants in ambient air is generally due to numerous and diverse sources. And we know that the states are charged with establishing the NAAQS, as you just heard. Okay, so these are national numeric air quality standards, okay, and these are set under 107, and they have to be sufficient to protect public health with allowing for an adequate margin of safety. And this is a challenge under the Clean Air Act. This is a challenge because setting health-based regulations is actually very difficult. There's issues of scientific uncertainty and evolving science. And one of the things that Don referenced earlier, and I'm guessing, was it the lead industries case maybe that he worked on as a law clerk?
No, it was the Ethel case, but same thing.
Yes, yes. So one of the things that we saw over time is EPA struggle to keep up with the evolving science. So where do you set that threshold where it's going to be an adequate margin of safety? And so you see things like the evolving science from epidemiology come into play with elevated blood lead levels and what that means for children. How do you deal with that? And when do you have to keep ratcheting down the NAAQS in response to this evolving science? Okay, so two nuances that I want to mention. And I don't have my, I don't know, oh, wait, I don't have my numbers on the slides here. But that's okay. I think we can stay on this one. Two nuances I want to mention regarding non-attainment after the state does these things, okay? So so we can ask ourselves, how is a state going to achieve these standards? And under Section 107, each state has to start with designation, okay? So they look at what's called, we could call it an airshed, they call it an air quality control region. They have to designate these areas as being in non-attainment, attainment, or unclassifiable for each criteria pollutant. And under Section 110, they then create these very large and complex and iterative plans to achieve the National Ambient Air Quality Standards. And then they submit them to EPA for approval. Two nuances worth mentioning on non-attainment. Under 107D1, a state has to designate as non-attainment an area that doesn't meet a NAAQ or contributes significantly to a nearby area that doesn't meet the National Ambient Air Quality Standards. And another thing to mention here is that, again, it's a fluid process. And if circumstances change, a state can always apply to EPA to upgrade from non-attainment to attainment. Because remember, as was introduced in the first presentation, if you are in an area of non-attainment, that is, you are not meeting the National Ambient Air Quality Standard for a specific pollutant, you are going to find yourself in a stricter regulatory regime for certain types of sources. Okay, so state has reason to try to fix these issues and then apply to EPA to say, hey, redesignate our areas. Okay, and then these are details here under Section 110, what a SIP must include. And it must include enforceable emission limitations and things like a schedule for compliance. Let's get these all up there. Okay, schedules for compliance to achieve the NAAQS, an air quality monitoring plan, enforcement programs, and incorporating technology-based emission limits that we'll chat about next. Okay, for non-attainment areas, again, states have to demonstrate that they're going to make reasonable further progress towards achieving attainment. That's Section 172C2, require a pre-construction permit for new or modified major sources. We'll talk about that particular statutory term in a moment, and that's under Section 172C5, and require those offsets and that require those incremental progress goals that Don talked about earlier. Okay. Okay, so let's talk a little bit about accountability in that SIP process. This is sort of the quintessential cooperative federalism dance that was introduced in this first presentation. And it's this shifting balance of power between EPA and the federal government and the states, okay? So in other words, the states get to choose the methods of achieving the statute's air quality protection and improvement goals. And they do that through an exercise of their own discretion. How do they want to divvy up those, the regulatory burden among sources in the state, okay? And they can consider certain economic and technical factors when they exercise that discretion in divvying up that burden. So for example, they can think about where the most economically efficient place to squeeze might be. They can think about where it might be most politically troublesome to squeeze a little bit harder. Okay, so all of these things allow states a little play in the joints to figure that out through some independence. But there's accountability and federal oversight baked into that process. Okay, and ultimately, EPA has to approve the SIP, as you know, and if it doesn't find a SIP adequate under Section 110, it can impose a federal implementation plan, and it can say, here, we've chosen for you FIP, so FIP'em, that's what it means. And it could increase the amount of offsets required for a new or modified source, or it could take the step of withholding federal transportation funds. None of these are used terribly often. They have been used in the past, but they're not used terribly often. What's interesting, and maybe I don't know if Martha was going to talk about this, but under the Clean Power Plan that was written under the Obama administration, I believe when the stay got put in place, EPA was just finishing the FIP. Is that right? Yeah, yeah. So this is still something that's going on. Thank you. Today. So again, the point here is this is not a static process. This is an iterative process. So just as Don said, you know, show me the state implementation plan. Well, it's not actually an easily read document or a plan. It's something that is more fluid. Okay, so there's I won't go into all of this right now, but there's other statutory provisions if the states want to revise their SIP, things like that. Okay, so again, takeaway is this federal cooperative federalism structure allows flexibility, accountability, but at the same time, the statute provides the bounds for the dance. It provides rules and a structure for EPA to look at a SIP and say, is this acceptable or not? Okay. So now we're going to talk about some of these technology-based performance standards. And these are the regulatory programs. And these are really the regulation part of the Clean Air Act. The SIP is sort of how they're put together, how a state shapes its compliance with the National Ambient Air Quality Standards, and these are the technology-based standards. Okay, so let's talk a little bit about this. These are incredibly complex pieces of legislation and regulation, so I'm going to talk about them and introduce them to you, but they could, you know, any of these could be a whole class, a whole lecture, and they are actually sometimes attorneys' entire careers. Okay, so that's how complex these areas really are in real life. So let's try to touch upon them briefly so you can at least say you know a little bit about them. Enough to be dangerous, I always say. So new source performance standards, I like Don I think called it an engineering program, and I like that. I think that's a great way to think about it. These are categorical standards created by EPA by regulation on an industry by industry and pollutant by pollutant basis. They cover all new or modified sources that fit within that category. And it's a uniform standard regardless of the status of the area as attainment or non-attainment. So that's really important when we think about new source performance standards. New source review, on the other hand, is done on a case-by-case basis, only if you qualify as a new or modified major source. It occurs for all air pollutants other than HAPS, hazardous air pollutants. And here, there are different standards based on the quality of the air, whether you're in attainment or non-attainment for a certain criteria pollutant, okay? There we go. And again, not to repeat too much of what you've heard before, but again, new source performance standards, we want to think about them being set on an industry by industry, pollutant by pollutant basis more uniformly. That's going to be section 111B1. I won't bother to read to you the critical parts of the act, but section 111 is where we find the details of the new source performance standards, and I think Martha's going to talk about today's really important application of these standards to hot topics. A new source review, on the other hand, I think is, I do want to touch in some detail here. Again, this is on a source by source basis and applies to all new and modified major sources. And I want to highlight for you some statutory terms here. So we have, as Don said, new doesn't always just mean new, it can be modified. And we're talking about major sources. So if you're thinking about practicing in these areas of law, these are the types of nuances and regulatory definitions that are going to become your bread and butter. These are really seriously litigated topics under the Clean Air Act. What constitutes a modification? Hugely important issue. You know, how do we know if a source is major? How are we measuring the output of a certain pollutant to qualify it as major? So the statute and regulations answer some of these questions, but there are always things to litigate, and this is very, very hotly litigated area, okay? So we see how the term major is defined and how these programs define modification, again, has tremendous implications for the requirements of a source in a particular area. The other thing that I want to highlight for you about new source review is that it's different. Again, the requirements are different based on the quality of the air where you are. In attainment areas, this is referred to as prevention of significant deterioration. In non-attainments, it's non-attainment new source review. Okay, so let's talk about some of this quickly. Non-attainment new source review applies if emissions of a pollutant are in an area of non-attainment. It requires what's called a layer, the application of the lowest achievable emissions rate. The easiest way to think of layer is that this is the most stringent emission limitation applied to a comparable source, with costs only considered if a standard would prevent that source from being constructed. And it also requires offsets as well. Under the Prevention of Significant Deterioration program, a source emitting a pollutant for which the area is in attainment, they have to comply with BACT, which you heard mentioned earlier, the best available control technology. It's the best technologically feasible option that is not ruled out by adverse energy, environmental, or economic impacts. All right, let's talk a little bit about prevention of significant deterioration. And I think, again, I always go back to when I'm working with students and sort of hashing our way through these concepts, which takes us much longer to do in a regular environmental law class. But when we're hashing out these concepts, they hear me go back over and over again to the purpose of each of these statutory provisions. Because if we think about the purpose, it will drive why the provisions require what they do. And here, with prevention of significant deterioration, remember, we're talking about areas where the air quality is good for a certain pollutant. So this is Congress and EPA saying, how do we allow for sources to operate without deteriorating, without making the air quality worse, okay? And so these basics that I have on the screen here are what we've come to for that, okay? So we have to have provisions to protect good air quality under Section 110A2J, and we have to have a pre-construction review process for major emitting facilities constructed in these areas. Again, one of the examples of how this, all these various air programs can create much better air quality. I was going to go into some detail about this particular story, but I don't have time. But you can see up there, it looks pretty good, and it sort of harkens back to what Don said earlier about being in DC in the summertime and not seeing across the street. And this is the Great Smoky, these are the Great Smoky Mountains, which is one of the areas hardest hit by regional pollution coming from coal-fired powered plants in a different area. All right, so quickly, because I think that probably the most interesting part of my presentation is at the end, as is probably the worst place to put it. But just so you know some of, again, the nuts and bolts of how this, when the rubber hits the road and we talk about permitting. Okay, so I mentioned earlier that there are pre-construction permit requirements for a source under the Prevention of Significant Deterioration program, and there's a robust process that these potential sources have to go through to prove essentially all of these details that I have written up here. Go to proving that you're not going to harm or deteriorate the quality of air in an area that's already in attainment. And I think I'm going to skip over HAPs for time purposes. Martha's going to talk about mercury air toxics, and I think that's more interesting anyway, and Don mentioned these. Okay, so one thing I think you should all hear about before leaving here today is Title V. And Title V, as you know, came about during the 1990 amendments, and this requires regulated entities to obtain an operating permit. And what's key here is that Title V actually doesn't impose any substantive requirements. It consolidates the requirements imposed by other regulatory programs, including those imposed by states through their SIPs, all in one permit. Okay, so this is the all-in-one place where you find what you're supposed to do as a source. So it makes it easy for the regulated source, makes it easy for the regulators and citizens to identify the requirements for a particular source, okay? So we'll go through, if you're interested in this, again, these are all the components of what you would consider when you're putting together the Title V permit, okay? So you can consider those one and the same. Title V permit is your operating permit and puts together all the requirements in one place, all right? And finally, just a quick reminder that the term major and how it's defined based on the program that you're under in the Clean Air Act is a critical piece that's going to be the triggering term for many of the requirements that we've just run through. Okay, so we've talked about Title I in some detail. I wanted to, I don't have much time, but I at least wanted to touch on a really interesting case, and I wanted to, this was just a great opportunity in my class this fall for environmental law. I got to have two of my former colleagues from the environmental enforcement section come in and teach a lesson on the Volkswagen case. So they got to come through and do this, and it's a fascinating case. It was a tremendously successful case against Volkswagen, and by Volkswagen we also mean portions of Audi and Porsche. And they found these amazing cartoons, so I felt that I needed to share much of this with you. Okay, so I'll go through this quickly, although it really is a fascinating story. So just as a reminder, mobile sources under the Clean Air Act, we're talking about light-duty vehicles, heavy-duty vehicles, fuel standards, non-road engines and vehicles and aircraft. And there's important regulations for when those engines come into this country, when they're imported into this country. And there's regulations that they have to follow, just the same as under Title I that we've gone through. So for example, before the key ones here are that before a manufacturer can legally import or introduce a vehicle or engine into commerce in the United States, it has to be covered by something called a certificate of conformity. And those are issued by EPA. And the application includes emission testing, okay? And there's certain procedures that you follow when you do an emissions test. And the California Air Resources Board, CARB, separately regulates engines sold in California, as Don had mentioned. So those are just the key things I want in your mind for a moment. And so when we think about these vehicle and engine conformity requirements, there can be something called a defeat device. Do you all know that this case was about defeat devices? Okay, so defeat devices say, hey, this engine knows when it's being tested, when it's in a test phase, and it's going to change its operation when it's in a test phase, and it's going to emit less. Okay, so defeat devices are illegal under the Clean Air Act Title II, okay? And what happened in this case is ultimately Volkswagen wanted to introduce what they called clean diesel in the United States. But they ran into a problem. They could not have the performance and the features they wanted in those cars and obtain the proper emission standards. And to work around that issue, they created a defeat device. And they even sent some of their engineers over to perfect the defeat device here in the United States, okay? So we'll go through this again. I'm in my last minute here, but to make a long story short, eventually the defeat devices were discovered. There were indications in Europe, and then the whispers came over to the United States and were pursued very quickly and aggressively by CARB and the EPA for this case. And ultimately, it led to very successful civil and criminal claims against some individuals and the Volkswagen company in general, and led to tremendously successful consent decrees that I could talk a long time about because I'm a former enforcement attorney. But there are some very creative portions of these consent decrees that are worth mentioning. Obvious ones include the buyback and the recall, but there was also zero emission vehicle portions of the consent decree and a mitigation trust that were also created. And I think that those were that they were good creative solutions to this problem, and Volkswagen was actually interested in performing a lot of these portions of the consent decree. The negotiators were able to find areas of mutual interest to make this happen. So bottom line, huge numbers in terms of civil penalties and injunctive relief, up into the billions, the biggest of any Clean Air Act case. So that was very short shrift to an amazing case, but at least one example of enforcement. And with that, I think I'm over my time. I used up Don's extra minutes. So I'm going to give the control over to Martha.
Great. Great, thank you all so much. Thank you to the Environmental Law Institute for holding this event. It's really a pleasure to be here and to join Sarah and Dawn and talk about, Dawn, also my favorite subject, Clean Air Act. So my name is Martha Roberts. I am an attorney with Environmental Defense Fund here in our DC office, where I work on federal climate and air safeguards. And here's just a quick look at what I'm hoping to cover today. So we've heard from Dawn and Sarah some of the building blocks and some of the amazing history of the Clean Air Act. I want to give some picture of activity that's happening now and a little bit of a vision of looking forward into the future. And in particular, I want to focus on three different challenges, you might say, that are facing the agency right now. One is the urgent challenge of securing a stable climate, and what are the opportunities and the context that we have at the current moment under the Clean Air Act. And I'm going to focus in a little bit more detail on the current clean car standards, as well as the Clean Power Plan, as to really highly salient developments that are moving right now in the space. But I also do want to talk about the remaining challenge of addressing air pollution in this country, where the work under the Clean Air Act, there has been a lot of progress, but the work is still certainly unfinished. And finally, I want to talk, hopefully I'll have time to just briefly touch on some of the procedural aspects of the Clean Air Act that I think, you know, for you all starting to dig into the Clean Air Act, it's really important to be thinking about how the decisions are made, because they really shape the outcome, needless to say. So let's start by talking about securing a stable climate under the Clean Air Act. And to start, you really have to start with the seminal environmental law case of Massachusetts versus EPA. So this is a 2007 case, and I think it's worth just reading some of the language from the opinion itself. So here the Supreme Court concluded that if EPA concludes on the basis of science that greenhouse gases endanger public health and welfare, then the Clean Air Act requires the agency to regulate emissions of the deleterious pollutants. And under the clear terms of the Clean Air Act, EPA can avoid taking further action only if it determines that greenhouse gases do not contribute to climate change, or if it provides some reasonable explanation as to why it cannot or will not regulate these emissions. So, you know, that's some of the foundational context here, that the Supreme Court concluding that EPA has an obligation under the Clean Air Act to address greenhouse gas emissions if the agency concludes that they harm public health and welfare. So some of the other important contexts to be aware of as we think about the agency tackling climate change under the Clean Air Act, I just want to briefly touch on some of the scientific and technical context that we face and the agency faces right now. And so crucially, in the aftermath of Massachusetts versus EPA in 2009, EPA issued an endangerment finding that on the basis of an extensive review of the science, the agency concluded that yes, indeed, greenhouse gases do endanger public health and welfare, and it codified it in this publication in the Federal Register. And we've seen since then subsequent major scientific reports come out that only further underscore the findings that the agency included in that 2009 publication. So we have the fourth national climate assessment, again saying there's no convincing alternative explanation for observed warming over recent years other than human activities, laying out with high confidence the expectation that under business as usual, the US will see 1.4 degrees centigrade increased warming just over the next few decades. Crucially, this is a publication that was released in 2017 by the US Global Change Research Program, which is a consortium of federal agencies. So this is a publication of the Trump administration, and the federal consortium does include EPA. So this is a federal government, US government publication underscoring the tremendous risks that the country faces from climate change. More recently, we've seen the Intergovernmental Panel on Climate Change issue another crucial scientific assessment that focused on global warming of 1.5 degrees centigrade, and it looked at the differential harms that come from just another 0.5 degrees centigrade of warming. So 1.5 degrees versus 2 degrees, and underscored the tremendously more substantial risks that communities face if we are failed to limit warming to 1.5 degrees. And it also laid out pathways, emissions pathways, consistent with limiting warming to 1.5 degrees, and found that global net anthropogenic CO2 emissions must decline by about 45% by 2030. That's 11 years from now, and reach net zero by about 2050. So, you know, we have a, so here is, you know, a complementary piece of information, which is the U.S., the historic on the left side, and then the projected emissions trajectory, carbon emissions trajectory for various different sectors. So you see there's some modest reductions in emissions from the power sector in recent past years, but really not on the scale that's necessary to tackle this tremendous challenge. And certainly looking forward into the future, the expectation, this is the Energy Information Administration, projects stable emissions. So not even achieving any reduction. So certainly the scale of the challenge and the pathway that we're on do not match. Now, there is hopeful context to also apparently only very quickly be aware of, which is the, you know, it's important to recognize there are technologies that are available that provide, you know, solutions, and increasingly solutions at scale. So we have on the left here the price of wind energy, electricity, and on the right the price of solar electricity, dropping dramatically. This is just over 9 years. The price of utility scale solar is much too small, but has decreased by 88%. So extraordinary declines, very encouraging. We similarly have dramatic declines in the cost of batteries, which are a crucial technology for transitioning to electric vehicles, which of course are zero emitting, as well as 24/7 renewable energy sources, because they can be matched with solar and wind. And similarly, dramatic price declines in these in battery technology. So the context that we face, we have a command from the Supreme Court that EPA has an obligation to address these emissions if they are harmful to human health and welfare. EPA has concluded, and the science continues to underscore just to what a dramatic degree they are. We have technologies increasingly that are available at, you know, low cost to provide solutions. You know, I'll be blunt, that's absolutely can't be squared with the actions of the Trump administration to date. So we see across the board, we've seen with this administration an effort to weaken and roll back existing programs to address climate change under the Clean Air Act. And Don, I'll with great respect, slightly push back on your point, which is to say, I entirely concur that the Clean Air Act, it's a challenge to think that the Clean Air Act is fully up to the challenge of addressing climate change under the existing statutory language that we have. But there are, and these programs that are being rolled back are existing programs that meaningfully tackle climate change.
I was the first person to argue we could use the Clean Air Act to regulate
there
climate.
You go. Right. I knew you'd come around.
In 2008.
So there are, you know, perhaps not up to the scale of the challenge. Certainly, I'd argue the existing programs could be more ambitious. But there are programs on the books that address greenhouse gases from the power sector, from the transportation sector, oil and gas, landfills. You know, you can go on and on. This administration has been working quite systematically to weaken and undermine those. And a crucial feature, omission to the list of efforts that they've undertaken, is there's been no formal proposal to revoke the foundational 2009 endangerment finding. So you'll hear the president use language disparaging climate science. You'll hear that from senior EPA political officials, but there has actually been no meaningful regulatory move to roll back to reverse that finding, which is, of course, the crucial legal trigger for these programs. And I'm going to walk through in more detail the Clean Power Plan and the Clean Car Standards. And to me, this disparity between where the science, what the science commands, and where this administration is moving, you know, as you get into the details, becomes clearer and clearer. But first, let's talk a little bit about these programs, the ones that are, or at least until very recently, were on the books. So the 2015 Clean Power Plan, this was a program to address carbon pollution from existing power plants under Section 111D. So Don and Sarah both mentioned new source performance standards. That's under Section 111B of the Clean Air Act. There are complementary standards for greenhouse gases from new power plants, but the Clean Power Plan was operating under 111D and was focused on existing power plants, which are the largest stationary source of greenhouse gas emissions in the US. So crucial part of the puzzle for solving climate change and reducing our emissions here. So there's three key elements in the Clean Power Plan, excuse me. The first is that EPA determined the best system of emission reduction for existing power plants. And that terminology, the BSCR, comes straight from Section 111. And EPA determined that this best system was reflected what they called three different building blocks. So the first was efficiency improvements or heat rate improvements at existing coal-fired power plants. The second was the shifting of generation to lower emitting existing natural gas facilities. And the third was shifting of generation to new renewable energy facilities. And the second crucial piece of the Clean Power Plan was that based on those three building blocks, EPA calculated, they set targets for emissions from a natural gas-fired power plant, and then a distinct target for coal-fired power plants that were based on the BSCR. And then the final crucial part of the Clean Power Plan was that the agency provided guidance to states on how to achieve those standards. And notice, you know, there's been, we've discussed today the structure of the NAAQS program where EPA sets a standard and then the states are tasked with finding ways to meet the standard that EPA has set. That framework is somewhat echoed in the approach that the Clean Power Plan took, and I think it's very helpful in sort of thinking about how it worked to remember that basic foundational structure of the Clean Air Act. So when this program was issued, it was estimated that it would reduce carbon pollution from these existing power plants by about 32% below 2005 levels by 2030. So the recent ACE rule that was issued by this administration, and in fact just published in the Federal Register yesterday, finalizes the repeal of the Clean Power Plan. And it instead puts as a type of replacement a new emission guidelines also issued under Section 111D. But there's numerous differences that are really important to explore. And I think I would say the two crucial ones are, first of all, it's directing states to consider only efficiency improvements at existing coal-fired power plants as part of the best system of emission reduction. So recall the Clean Power Plan had the three building blocks. First one was efficiency improvements at coal-fired power plants, but then it was generation shifting to lower emitting sources. So this approach solely looks at efficiency improvements at existing coal-fired power plants. Another distinction that's equally, if not even more important, is that instead of EPA establishing a rate, and directing states to work to create a plan to meet that rate, EPA actually just directed states to look at these efficiency improvements on a case-by-case basis for each unit. So there's actually no binding limits in the guidelines on carbon pollution. So there are a lot of really interesting takeaways from the ACE rule as compared to the Clean Power Plan. I think a few that I would point to is one is that the real choice in the ACE rule to disregard the main method that power companies are actually using in the real world to reduce emissions, which is by shifting generation from very high polluting coal-fired power plants to lower emitting sources, which is an extremely low cost way to reduce emissions. The ACE rule disregards that option and instead focuses on these heat rate improvements, which actually, because they make coal plants more efficient, has the potential to make them operate more and thereby release more pollution overall. And my colleagues at EDF actually just unpacked the EPA data just last week and found that if you look at a state-by-state basis, EPA's own analysis expects that 16 states will actually increase their carbon pollution under this their rule. So it's quite hard to square that with the best system of emission reduction. I'll leave it at that. So the other takeaway is that that's really, we could spend hours talking about this. It's fascinating that they've actually set aside this flexible approach of providing for trading and averaging and compliance, which was woven into the Clean Power Plan, and instead actually mandate compliance at the unit level. So Don, you talked about the bubbling concept going back to the 80s. This is kind of going back into reverse and requiring compliance at the unit level, which is, there's decades of experience that that's a higher cost, less flexible way that the industry itself does not prefer. So it's another really notable feature of this the ACE rule. There's also important, and I'll get to this at the very end in a little bit more detail, but the analysis of the rule assumes away significant portions of the health benefits of reducing particulate matter that comes with, that is an impact of rolling back these standards. Similarly disregards a lot of the impacts of climate pollution. And just generally the rule, it's an enormous missed opportunity for really achieving very low cost emission reductions that are crucially needed in the next decade to tackle climate change. So it's just a tragic missed opportunity. But I gotta keep moving forward. So the clean car standards are another important and very active area right now in the challenge of tackling climate change under the Clean Air Act. So just looking at the sort of recent history, in 2009, EPA responded to a California petition. Don mentioned the idea that there's a particular authority for California to establish standards in other states to adopt those more protective car standards. 2009, EPA responded to an EPA petition and granted this preemption waiver, allowing California to start its own more stringent greenhouse gas vehicle program. In the end, in 2010, President Obama negotiated as part of the auto bailout this one national program where California, EPA, and Department of Transportation issued a set of a joint rulemaking that set out greenhouse gas emission standards and fuel economy standards that were harmonized to allow for one car throughout the country. 2012, those were updated for future years, and these are standards that apply to cars and trucks. So this administration has proposed to dramatically weaken the standards that are in place for 2021 to 2025. The EPA standards in place right now would gradually increase in stringency by about 5% a year. The proposal would provide for zero improvement, establish fuel economy standards with zero annual improvement. It would also have two different efforts to attack state clean car authority the California and state program that has now been adopted by 14 states total. And there's a lot of remarkable aspects of the analysis that the administration has used in an effort to justify this rollback. Just two that I'll point to is the fact that the administration itself estimated that its rollback would lead to 7.4 billion tons of additional carbon pollution. And their reasoning, again, it's fascinating. There's no grappling with the climate science or effort to conclude that climate change is not as big a problem as the science directs. Instead, the agency, there's actually an extraordinary passage where they conclude that in 2100, the rollback would only make a difference between global levels of global concentrations of CO2 of it being 789.1 parts per million as compared to 789.8 parts per million in 2001. And so they say it's not really a substantial difference, so it's not worth taking on the concerns that they have about the current standard. It's just extraordinary to see. It's basically ceding the field and conceding, that kind of reasoning essentially concedes that there will be a level of carbon dioxide concentrations that I'm not sure is even considered in scientific assessments on impacts, and that's an extraordinarily high level. So there's also evidence that EPA was really shut out of the decision making. There's remarkable materials in the docket showing that EPA actually tried to get their logo, the EPA staff tried to get their logo deleted from the regulatory impact analysis because they were not involved in preparing it. So, I'll try to keep moving. I think what's really important to think about is, again, just going back to the language of Massachusetts versus EPA, where the agency is charged with protecting the public's health and welfare, and the court itself recognizes that that's an obligation wholly independent of DOT's mandate to promote energy efficiency. So we see the agency in some ways ceding the field to the Department of Transportation, which there's many reasons to think has basically run this whole rulemaking. And rather, it's basically in operation, eviscerating the conclusion of Massachusetts versus EPA, which is that EPA has an obligation to address this dangerous pollution. So in operation, they've constrained the agency's ability to operate under 111D and also under clean car standards. These are provisions that give EPA authority that are on the books, but the way this administration is interpreting them really ties the agency's hands. So, I think what's important to think about looking forward, it's deeply concerning to me to watch the administration move in this direction. At the same time, the administration has had an just tremendously unsuccessful record in judicial review. So NYU Law's Institute for Policy Integrity has kept track of all the administration's deregulatory efforts. Over 90% of them have failed in court, which is absolutely can't really be compared to other administrations. It's just much less successful. You also see the administration is really way behind in all of the rollbacks that they are working on. So I listed off that they're systematically working on them, but the Clean Power Plan repeal, which was a signature presidential level priority of this administration, only just made it at the door, and we're 2.5 years into this administration. So they're quite delayed. A lot of the other rollbacks that I mentioned are still in the middle of the rulemaking process, and it's a challenge to think that they will get through judicial review during this term. Moreover, as I mentioned, it's really hard to think that they will survive judicial review, since it's so challenging to see how they can be squared with the science and the facts on the ground. So that's, to me, good news that I think there's a real challenge in seeing how these this direction for the Clean Air Act, this very limiting approach to how the Clean Air Act can be used to address climate change. It's hard to see how that will succeed in court. At the same time, we need to be moving forward ambitiously right now to address this urgent problem. We see progress at the state level, but even just standing still at the federal level is far insufficient. So I am just going to whip through the two other pieces that I did want to talk about, but I can't possibly let you all leave here without touching on the unfinished work of the Clean Air Act in addressing conventional and hazardous air pollution, as well as some of the issues related to science and decision making. So there has been an enormous record of success in addressing conventional air pollution under the Clean Air Act, but there's a lot more work to be done. The latest science continues to underscore that pollution, there are even more threats and harms from it than we may have understood previously. Over 140 million Americans healthy air. There's a tremendous challenge, has been a longstanding failure of the Clean Air Act in addressing pollution hotspots. That's been well understood for a long time. It's now even clearer as monitoring technology really shows what a problem that is. Unfortunately, we again see the Trump moving in the opposite direction. So this is a map that just shows downtown Oakland. I had some colleagues that worked on placing air quality monitors on Google Street View cars. So they were this hyperlocal monitoring. As what you can see is that pollution related to traffic there's just tremendous geographic disparities. The chart shows that you'll have 4 times, 5 times more pollution the closer that you are to a major traffic hub. And so the NACs, which focus on this very regional level air quality and often have sometimes 1 or 2 monitors in a whole state, are really struggle to capture the real harms and the real exposures to air pollution that you see from this kind of geographic diversity. And similar, there's a slightly different but similar challenge with hazardous air pollutants, where because they're based at the unit by unit level, you can have a concentration of sources that emit hazardous air pollutants, and you have a very high levels in aggregate, a hotspot of hazardous air pollutants. And this has been a major challenge to address under the Clean Air Act. These hotspots are, it's across the board shown that they are usually happen in communities of color and in low-income communities that are already overburdened. It's a crucial challenge that the Clean Air Act has struggled to address. I'm going to skip over the mercury and air toxic standards, and this is another initiative of the Trump administration to undermine a tremendously successful program. And just because I think it's important, I want to close by just talking a little bit and mentioning the idea of some of these below the radar guidance documents, sometimes rulemakings, memos that are about how decisions get made under the Clean Air Act. And I think for those of you who are embarking on exploring the Clean Air Act and understanding how it works, it's incredibly, there's all of these nooks and crannies, a lot of twists and turns, but I would encourage you to not, in looking at the statutory provisions and understanding those and the different programs, don't lose sight of these, again, somewhat under the radar changes that are about what benefits get to be considered in a rulemaking, what scientists get to be the experts to provide inputs, what science gets to be considered as a part of a rulemaking, because these are how the decisions themselves get made. There's a tremendous amount of activity in the Trump administration to change these aspects of how decisions get made, with really cross-cutting dramatic implications for the actual standards and outcomes that you see. And one of them that's quite significant is this censored science proposal that would limit the agency's ability to consider public health studies where all of the data cannot be made available. I think it's a feature and not a bug of that rule that would preclude the agency from considering some foundational epidemiological research that really undergirds some of the most important public health standards that we have. So quite a real threat to thoughtful public policy and decision making. So I'll close. Don, I really was thrilled. I think you started sort of along the same lines of this chart, which I really love. It's sort of hidden in EPA's website.
It's in my article.
Right. Okay. There you go. Yeah. So, you know, there's an extraordinary history of success under the Clean Air Act. It's a remarkable public policy that has done a huge amount of good for the country, perhaps not as fast or as cheaply. But I think that there are really crucial tools that can be used under the Act as it exists now to tackle climate change, to tackle air pollution. It's very concerning to see the direction the administration is moving on those issues, but I think that they are very legally vulnerable, and I have hopes that, you know, with a new direction and a more thoughtful application of the Act, that there can be more of a record of progress moving into the future. So thanks so much.
Thank you all. I'd like to open the floor up for any brief questions that we have for the panel. Any in the room? Oh, yep, all right.
Thank you all so much for speaking today. Very interesting. I just want to go back to kind of the question that would wrap up this, whoever wants to speak on it, but we don't have 25 years to wait for the Clean Air Act to affect the most change. And we're all here because we want to further the law, to push it in the right direction, or at least use the Clean Air Act in a way to affect the most change in our own lifetime. So what advice, I know you just spoke about how we can use these last two kind of topics to push the law, but if there's any expert advice you'd like to share with the room, I'd appreciate that.
Well, I'll start. It is a difficult problem, and I think using the existing Clean Air Act probably suboptimal as opposed to passing legislation that's really tailored to that. What I advocated in 2008 was the use of the National Ambient Air Quality Standards and state implementation plans, which had a proven record of success. I'm sympathetic to many aspects of the Clean Power Plan. It was designed by one of my former students, Megan Sharansky, and a lot of the things about the importance of, you know, trade-offs and good policy make a lot of sense. I think one of the things that Martha didn't mention that I think is really material is that the Supreme Court issued a stay, extraordinary action, saying that the Clean Power Plan was probably illegal and stopped it in its tracks. So while there were elements of it that were very good policy, there were aspects of it that that the Supreme Court found difficult to square with the language of the statute. So, you know, I think maybe it was better policy than it was being consistent with but it was particularly the aspects that Martha likes and that I like from a policy standpoint of encouraging the development of renewables, the so-called regulation outside the fence line. That was what the Supreme Court found debatable about it. So I guess I think that ultimately with regard to climate change, if we're going to address climate change, it's going to have to be through a combination of measures in which the reduction of and I've written some things about this. I have an article in the American Spectator you can find online. It's called What's Really Wrong with the Clean New Deal. And it basically talks about how if you're going to try to deal with climate change, you don't necessarily just, I mean, assuming, and I think the evidence is pretty strong, that human use of fossil fuels has contributed significantly to global warming, it does, or global climate change, doesn't necessarily follow that reversing that process is the only way to deal with it. And I think it's much more likely that we're going to have a composite approach eventually. But it is a very difficult problem. Some people have written about climate change as the public choice problem that ate the world, whatever it is. Because I think one of the great difficulties with it is that it got people got in touch with it in terms of predicting things far off in the future, and not really doing a recognition that, you know, a lot of these factors are actually at play already. I mean, I heard a really quite remarkable presentation, an unfortunate way, by Bill Ruckelshaus, the first administrator of EPA, who really saved it in the Reagan administration. He talked about climate change as something that's going to happen 50 years in the future, and he'd be dead, and it wouldn't really affect him. And I think that mindset has affected an awful lot of people. I think another aspect of it that is one of the things that the Trump administration is, and I'm not defending him, I'm actually the chair of the advisory board of the NYU Center of Policy Integrity that was mentioned. But I think one of the things that makes the problem difficult is that while we're reducing our CO2 emissions for a variety of reasons, largely natural gas from fracking, there are, you know, like 2,000 coal-fired power plants that are being constructed in the rest of the world. And so I think it's very difficult to address the problem without having, you know, an international approach. And I think that's one of the things that the Trump administration is concerned about. But yeah, I think it's a very difficult thing. I think that there were better ways to address it under the Clean Air Act. Having said that, the primary designer of the Clean Power Plan, or one of the primary designers, is my colleague at Covington, Gary Guzzi, who's been a friend of mine for 20 years or so. But I do think that the use of 111D was a risky approach from a statutory standpoint. And the Supreme Court, you know, stopped them in their tracks. So talking about it as good policy, but not mentioning the fact that the Supreme Court at least felt it couldn't be squared with the language of the statute is a problem.
I think one thing I'll offer to one opportunity that I think is a really valuable one and gets at the sort of history of the Clean Air Act is that state action right now, opportunities to make progress at the federal level are limited under this administration. There's no way to get around that. The Clean Air Act has an incredible history of basically taking successful models from the state level and subsuming them, you know, turning them into a federal program. And you see that happening right now, where there are states across the country that are really picking up the mantle and running with it and creating models and actually operationalizing them in a way where you learn the problems and the nuts and bolts in a way that can really provide a springboard for federal progress when we actually have an opportunity to do so. And now I guess I will say that you're correct that I left out the stay, but the Supreme Court actually didn't offer any explication for the stay, and so it is an opportunity for debate of what the basis was for the actual provision of that stay.
Well, that was really the only argument that people made against it, and the Supreme Court held that there was a probability of success on the merits. That's extraordinary. I don't think the Supreme Court has ever done that I can think of before in a major environmental, you know, initiative. I agree with the state initiatives. You know, I was involved with a friend and colleague of mine in doing the legal work that set up RGGI. So, you know, I think there are really some very positive things. I have a little article called Why the United States Doesn't Have a Renewable Energy Policy, but one of the things I point out in that is we do have a lot of renewable energy policies at the state level. The majority of our states have renewable portfolio standards. It's not enough to deal with some of the things, but I do think that there are some positive signs that we can that we can build on. One of the things that I think is most promising is there are now pilot plants that will take the CO2 out of the atmosphere and you know, turn it into useful products. You can remanufacture fuels out of the. So I think it's going to be a combination of responses, but I do think there's going to be some adaptation. I think we're going to be having to harden infrastructure. And I think we're going to be seeing more of the kinds of events that we saw in Washington yesterday.
I want to just add to this as well. I completely agree with what my colleagues have said about this. This is going to have to be a composite approach with policy and legislation. And this technical component, I think, is very important, whether it's these pilot plants or carbon sequestration, which I think Don was hinting at earlier, and the fact that it needs to be a multinational approach. I think that's all fairly, I think that's a safe bet as well. But one thing I'll just throw out there, in case you want to do something right now that you can work on as a young attorney, I'm going to go back to my enforcement roots and say there's still opportunities right now to make the most out of our current provisions relating to environmental enforcement that can be used at the state level and particularly from citizen suit provisions. And when we hold sources accountable for their pollution, we not only tackle some of these conventional pollutants that Martha was talking about, but sometimes we get the co-benefit of other greenhouse gas emissions reductions as well. And I would just, on a concrete basis, I would point you to some work that we were doing at DOJ under the Obama administration. We had started to use a more flexible approach to things like supplemental environmental projects that could work towards reducing emissions, or at least creating a catalog of carbon emissions, things of that nature. So there's some flexibility and creativity options in our current enforcement system. That's not going to be the solution for a worldwide problem, but it's a start. It's something you can do now. Yeah.
Thank you. We have time for one final question.
Thank you all for this great presentation, and also for your work over the years and the stories you've told about how regulations have helped in the last 450 years. My question is part policy and part politics, trying to get it under the wire. So most of what was discussed today was focused on emissions and tailpipes. Can you talk a little bit about legislating a carbon price at the source of pollution, which, let's speak economists think be efficient and effective way to reduce carbon emissions? And it would have bipartisan support. It would be economy-wide, so it wouldn't just be like the large major producers. I think we were talking about, like, people like to drive cars, want to run our air conditioners in this heat.
Yes.
And I definitely agree we need some regulations. I don't think market-only solutions would, ensure equity. But what do you think about carbon pricing as a major component of the climate solution? And if not market solutions, which has bipartisan support, what viable political path to addressing climate change do you see?
Well, I'll start, unless you want to.
No.
Well, yeah, I think there needs to be a price on carbon, because I think otherwise we are directing choices to be made based on the apparent price of articles that doesn't really take into account the full social cost. There are some interesting things that are happening in that area. One of the things is that the ISOs, the independent service operators, have currently an issue at FERC as to whether or not in making decisions about what is the least cost alternative source, they can take into account the CO2 effects of various energy technologies. So if that were to be adopted at FERC, it would make a really big move in that direction. The other thing I've advocated and have written some things about, and I presented this at a conference in Michigan a month or so ago, I think EPA can impose a user fee without additional legislation. So I don't think you have to pass a carbon tax, and I don't think as long as it's called a tax, the Republicans are very likely to do it. But it is a classic user fee, and there is a statute that specifically authorizes, and there are several $100 million of user fees that are imposed by federal agencies. So I think that's a very short way to actually do something. Now, to those who think that's not going to happen politically and plausibly, I would point out to you that it keeps fossil fuel use legal. So to the extent that the fossil fuel companies perceive themselves as being under a realistic threat of seeing their markets and their products decrease as a result of some of these state activities, they may regard having a user fee ultimately as being in their interest, as for example the cigarette companies did. Rather than ban cigarettes, we now tax them and make the government your partner. So I'm not as I'm not enthusiastic about a lot of the things the Trump administration is doing. I'm not trying to defend them, but I'm not as skeptical that we can't deal with this at all. But it is a daunting challenge, particularly under some of these worst case projections. I'll leave it at that.
Any final thoughts? All right. Well, I'd like to thank you all so much for joining us today and for your great questions. We hope you'll continue to think and learn about the Clean Air Act. You can stay updated with our summer school series on our website, eli.org. And next Tuesday, July 16th, we'll be diving into hazardous waste insights. I'd like to extend an enormous thank you to our fantastic panel, Don, Martha, and Sarah. Your vast knowledge on these topics and expertise are truly amazing, and we're so glad that you could join us today. Thank you all.